apologies.
Counsel Artis,
Yes. May
proceed.
it please the court, I'm Alicia Artis for the Department of Social Services in Erie County. We are requesting that this appeal be dismissed based on and affirm the findings of the trial court. If there's no questions from the panel, I can rest on my papers.
Very good. Thank you, counsel. Counsel?
Good morning, Your Honors. Jordan Principali on behalf of the child. I will rest on my papers, but would be happy to provide an update on how the child is doing.
Please.
The child recently celebrated a birthday last month. He turned 6 years old. This child was removed from the care of his parents when he was only 4 months old. So he's been in this placement with a family member since that time. This is the only home he has ever truly known. He enjoys going to school and he's doing very well. He will be completing kindergarten this year and he's starting first grade in the fall. He's incredibly bonded to this family. They continue to provide for all of his needs and he's very happy in this placement. He has expressed he would like this placement to be his forever home. Thank you.
Thank you, counsel. Cases 282, 283 in the matter of Dwayne McDuffie Jr. Greenberg, please proceed.
Thank you, Your Honors. I'm representing the mother, Ms. Coleman. Before I begin the central part of my argument, I just want to just give you a brief frame for that argument that this, of course, is the best interest of the children's standard is applicable here, and that the order under appeal is from May 30th, 2024. So as always, as seems to be the issue with visitation and custody petitions, we're asking to review facts from 2 years ago. And one fact that has changed since the order went into effect is that the elder of the two children is now over 18 years old. Her birthday was on March 29th, 2008. So we are now past that date. So she's now an adult and that kind of solves half the problem. So she's free to go see Ms. Coleman whenever she wishes.
So that appeal will be dismissed. Okay,
but for the younger of the two children, we would feel our argument would be that that it really was a very extreme giving the father, Mr. McDuffie, sole custody of her. The record does show that my client, did use the corporal punishment, but that was a one singular event. She does go to the mental health. She does go to, I think, specifically Beth Self, where they did not recommend any kind of drug treatment. And she also does visit with the children. So I would ask that you revisit that issue and then either grant her either kind of a joint custody situation or send it back to family court if you wish.
Thank you, counsel.
You're welcome.
May it please the court. Gary Muldoon for the younger daughter. I'm going to submit on my argument that's contained in the record. I think the record is replete with evidence of the parental difficulty in communicating and best interests, I think, are clearly shown that the children or the younger child should live with the father. What I wanted to do was to use my time to speak as to Michael B. Case to update the court. The child, the mother, I should note, had a neglect finding against her and an order of protection while the case was filed. The child, speaking of the younger daughter, has done much better in school since they began living with the father. The child is attending school in Cheektowaga at Cleveland Hill, is actively involved in the school, and is in junior honor roll. So the child seems to be doing well, is thriving, and so it is my position that the order of family court should be affirmed.
Thank you, counsel.
Thank you.
Case 284 in the matter of Dolores and Frederica. Just gonna wait for Mr. Barney to come online. Counsel, can you hear us?
Yes, I can. Can you hear me, Your Honor?
We can. Counsel, proceed.
Okay, thank you, Your Honors. And in this matter, I'm representing the father, who is Dolores Jr. One of the children is Dolores the third. My client, just to give you the frame for this appeal, has a very lengthy history with DSS, and that history is very contentious. He said the children were remanded before, he's gotten them back before, and then it keeps going back and forth. In this case, the older daughter, that is really the meat and potatoes of the case, is 17, so she's still a child. And the accusation was excessive corporal punishment, but excessive corporal punishment always has to be viewed in the context. And in this case, we had an out of control teenager who was off partying and getting into scenes that maybe she shouldn't have been getting into. And that was the context of her coming home and being hit. I mean, so that was the what instigated the whole current remand into foster care. So we would ask that the court really take a long, hard look as to the child's behavior and in the context. So this is not a case of, coming home with a bad report card and the child is 8 years old and then got hit for that reason. That was the reason we would ask that take a very hard look at those facts, and we would ask that you would reverse it and dismiss the petition. Now, for the second argument, if you don't wish to petition, then certainly find a different foster parent, because the current foster mother is the cousin of Dolores, Dolores Jr., and they don't get along very well. I mean, that too is a contentious relationship, and as I pointed out in my brief, maybe a fresh pair of eyes might not be such a bad idea. Have the children go to a foster house where they, I mean, granted, that maybe the counter argument is, well, they'd be strangers, they're not family. But sometimes, you might remove some of the, well, she's my cousin and I'm gonna let her get away with this or this, whereas a stranger might take a stronger approach to the children, that they keep them in line, and so they're not running around at night and whatever.
We'll take a look at those arguments, Counsel.
Oh, thank you, Your Honor.
Thank you.
Mm.
Counsel?
Yes, good morning, Your Honors. May it please the court, my name is Richard Barney, appearing on behalf of the Erie County Department of Social Services. I think one thing, obviously, in this case that the department could not deny is that respondent appellant's daughter, who I'll refer to as Child 1, she was exhibiting a lot of troublesome behaviors. That can't be denied. Clearly, there were some issues at school, that she was struggling with grades, and he rests upon that as the basis for engaging in corporal punishment against her. I think what must be viewed also in the record is that this is a child who repeatedly struggled mental health, had been to ECMC following self-harm attempts, had ongoing struggles, had reported to the respondent appellant that she was being bullied at school, and respondent appellant throughout this process was repeatedly dismissive of those mental health struggles. He stated his belief that it was his daughter who was causing the problems at school, despite the fact that there was testimony that she came to him saying she was being bullied. That's truly the context that we're operating in. Clearly, this is a child who had reached out for help. She asserts that she was pulled out of counseling following her most recent mental health issues, which found her at ECMC based upon the respondent's appellant's wishes. He states that the only time that he took her word was when she allegedly told him that she no longer needed to go to counseling. So there's another issue there in that he's not taking some of these concerns very seriously. Turning quickly to the placement, obviously respondent appellant argues against the current placement for both of the children, and again cites just some incidents that are getting back to him through Child 2, respondent appellant's son, that there is some lying going on, that Child 1 is telling lies about Child 2. Again, we can't deny that there have been some additional behavioral issues at the time of the dispositional hearing being shown by the children, but there was adequate testimony that both children were doing significantly better. Child 2, respondent appellant's son, had shown significant improvement in his grades. Child 1, while she was still having some troubles at school, she was attending. She had relinked with mental health. She was showing great strides as well. And the lower court found that the punishment being used by the foster parent was perfectly adequate based upon the situations that were arising. I think that given the trauma that these children have, the things that have happened to them over the course of their lives, it cannot be expected that they would turn a switch immediately once they got to a new foster home. At any rate, it would be, we would submit that it'd be more detrimental to both of these children to upset that foster placement at this point. As this case does proceed, my understanding is that they're both doing well in their placement. They both are very happy there. Both identify it as a safe and loving home for them, and both desire to keep their placement there. For all these reasons, we would ask this court to affirm both the findings of neglect against the respondent appellant, as well as the finding that the continued placement was in the children's best interest.
Thank you, counsel. Case 285, Deming Jr. versus County of Chautauqua. Proceed, counsel.
Good morning, Your Honors. May it please the court. This is a bar exam essay question, if I have ever seen one. What's the standard of review here? Casella made a motion to dismiss pursuant to 3211A7, right? That is the legal philosophy. If that which has been brought without evidence can be dismissed without evidence. That is the motion that we made. And the lower court judge made a decision that we hadn't proven our entitlement to summary judgment as a matter of law, but we didn't brief that issue before the lower court. So,
and there would have had to been a conversion, right?
Right.
The judge would have had to put everybody on notice that I'm converting this to a summary judgment motion and proceed along those lines. That was not done here.
it wasn't. Yeah. So we didn't brief that motion. We briefed the motion to dismiss, which should have been granted, and this court, of course, has the authority to do that on this record. There's no allegations in this complaint, this third-party complaint, that would lead to liability on Casella's part. Casella came a little bit late to this party.
Well, you're basing that on your private agreement with the company that you succeeded, correct?
That's correct,
But
Your
the
Honor.
county, was the county on notice of that? Did they accept that, and is that required?
You know, I don't know if they accepted it, and I don't think it's required because the Casella entered into its own contract with the county around the effective time of the purchase agreement with Bestway, who previously had held that work. And that was months after Mr. Deming's accident, months after it. So there's no liability under any.
So you're saying that Casella had a subsequent agreement with the county of Chautauqua
That's correct.
that said that they would not be liable for, are they liable under that agreement for injuries that happen while their contract's in effect?
Casella's,
Your argument is that they're not responsible for the prior one because they weren't a contract.
That's correct.
Party. And the county's saying, no, wait a minute, they just succeeded in this agreement, so, we weren't a party for that.
and that's not accurate, Your Honor, right?
Okay, well, that's your argument.
Yes.
But what about the current agreement? Is the current agreement, is your client responsible for injury? Like if this injury took place while your contract is in place, are they liable?
Yes. Yes, sir, they are, but not under the contract between Bestway and the county, because the purchase agreement between Bestway and Casella expressly took out from any retained liabilities any acquired liabilities, indemnification obligations that happened from incidents arising prior to the closing date.
Right, and that's between the two parties of the agreement. Why is the county on the hook for that? If there's no notice to them, if they didn't sign off on that.
Because Bestway is still here. Bestway still has the obligations it had to the county. Casella didn't assume those. Bestway retained those. Bestway's here. This lawsuit's going to go on. It's just that Casella is an appropriate party to it.
So just so I understand this correctly, your client took assets, not liabilities.
We took disclosed liabilities, of which there were none.
Okay, so but they were buying. It was pretty much an asset purchase agreement. Is what
It
you're
was
saying.
pretty much, although Bestway did retain some assets.
Okay, and there's exceptions to the general rule, right?
That's right, sir.
Yeah, and so if there's an argument to be made that one or two of those exceptions, I think there's 4 exceptions, if one or two of those exceptions apply, then this isn't a motion to dismiss case, because that's the standard we're looking at, right?
You got it. That's
Right.
exactly right.
Yeah.
And there's no factual allegations indicating that any of those exceptions would apply.
So your argument is that there's no factual allegations that there was a merger of seller and purchaser, for example?
That's correct.
And there's no factual allegations that the purchasing corporation was a mere continuation of the seller. And absent, and those are just 2 of the 4, but absent those 2, which are the 2 that I was looking at, you're saying that there's a complete absence of even an allegation of those, and as a result, a motion to dismiss should fail.
Yes, Your Honor. That's
Or
exactly
motion
it.
should succeed.
Should succeed.
Yeah,
Yes.
yeah. You're talking about 3211A7. Okay, very good. I think I have your argument, Counsel.
Thank you. If there's no other questions, I'll just step aside.
Good morning. May it please the court. I'm Kiefer Tian, counsel for the respondent, County of Chautauqua.
Does your opponent have it right? There's no even allegations of the 2 examples that I set forth?
No express allegations to that effect. I will not disagree with that. I think it's applied and alluded to in the allegations set forth that Casella adopted Bestway's allegations, and there was a merger and an acquisition of those.
So if there's even an implied circumstance here, you're saying that it's up to them to carry their burden with respect to the 3211 motion. And because you can possibly read the allegations in such a way to imply that there was a merger, that's enough for you to survive the motion to dismiss.
It's part of it, Your Honor. I think another part of it is that we have adequately pled a cause of action for contractual indemnification that is set forth in great detail in the third-party complaint.
Against Casella?
Against Casella as well as Bestway. We make the argument that at the time of Mr. Deming's unfortunate passing, the contract the contract involving the county was with Bestway. That agreement was binding on all heirs, successors, and assigns of Bestway, such as Casella. Casella then came in, adopted that exact same contract, expressly incorporated all terms by reference in a later agreement dated June 21st, 2021, that does not remove those liabilities mentioned. Those liabilities.
Are you saying that Casella, right? Am I saying that right?
Yep.
Yeah. That Casella, because that agreement that you just referenced was in existence, that Casella had no ability to do an asset purchase agreement, essentially, to avoid liability? That wasn't a possibility, that couldn't happen?
I think that they absolutely could have done an asset purchase agreement, and that is what happened here. But I believe that as a necessary component of that, we have to reconcile the 2 contracts together. The county was on notice, of course, of its contract with Bestway, and that was on notice that this contract was being assigned and assumed by Casella. Once we found that out, the county entered into its own contract with Casella that adopted all aspects of the previous contract between the county and Bestway.
But
Going forward.
This is a 30.
No, going forward.
Yes, going forwards, but it doesn't disclose any of the previous liabilities out there. Those are set forth in the asset purchase agreement, but the county, although on notice of a transaction between Bestway and Casella regarding the asset purchase agreement, we were not on notice of the exact terms of that contract.
Now you still have Bestway in this case.
We do still have Bestway in this case. That's right, Your Honor.
I guess I'm trying to figure out, what do you even want with Casella then? If you have Bestway, and they were around at the time this accident happened, I guess I'm confused as why you even want them hanging around in your case.
And absolutely. And the reason we included Casella, we initially filed a third-party complaint only against Bestway for that exact reason. And then it was kind of made known to us that Bestway was seeming to point the finger at Casella, arguing Casella adopted our liabilities as well, including the liability at issue in this case. And so to cover all bases and be sure the county was adequately protected, we filed an amended third-party complaint against both Bestway and Casella.
Right, but whether that's true or not almost doesn't matter at this point. Is the key point is you made the allegation that you just referred to, correct? Isn't that your, this is a 3211 motion. So as long as you make that allegation, you should survive 3211 motion to dismiss. Isn't that your argument?
That's exactly right, Your Honor. I think that is our primary argument. And I would also like to point out that because evidentiary material was submitted with the 3211 A7 motion, the standard also converts from whether the county has stated a cause of action to whether the county has a cause of action. I believe both are satisfied here. At the very least, the county adequately pled a cause of action for contractual indemnification. And I believe it also has causes of action for successor liability grounded in the exceptions that Your Honor just discussed with my colleague here. Namely, the de facto merger doctrine is the most prevalent one at issue in this case. We had Bestway and Casella go into an agreement together. On the other side of that agreement, only Casella emerged. Admittedly, it took a few years for Bestway to formally dissolve with the Secretary of State, but it sold all of its intangible property, including IP, its real property, its trucks, its containers, its entire customer list, its accounts receivable. For all intents and purposes, I know my colleague made the point that Bestway did indeed retain some assets. Everything that I've seen indicates that Bestway ceased to exist in everything besides official filing status with the Secretary of State following that asset purchase agreement.
And answer Justice Bannister's question that she posed to you earlier, that that's really the reason you want to sell in here, because they might be judgment proof.
And that's another part of it as well. We believe that Bestway has insurance that might be capable of satisfying some of if there is a finding of liability at the end of this case, to satisfy some of that judgment. But in the event it's not, that's another great answer to Justice Bannister's question that, yes, we do want to point to either Bestway or Casella. Frankly, the county doesn't take much of a position on between those two entities who is liable. We believe those can discuss amongst themselves and make those arguments there, but we believe that one of those entities at least is liable on the third-party complaint.
Anything further, counsel?
That's all I have, Your Honor. Thank you very much.
Thank you. Case 286, Calvinesso versus Meckel. Proceed, counsel.
Thank you, Your Honors. May it please the court, Tyler Eckert on behalf of Sean K. Mokel, Paul Fournier Enterprises, Inc., and Modern Disposal Services, Inc. We are asking this court to reverse the trial court's denial of bifurcation and find that the general presumption of bifurcation under Uniform Rule 20242A applies here for three reasons. First, the trial court failed to articulate any rationale for the basis of its decision. Second, neither of the two limited exceptions as outlined by this court's precedent apply in this case. And third, the danger of prejudice to the defendant appellants in this matter is severe given the long list of alleged injuries by the plaintiff, which may engender sympathy by the jury. Speaking to the first point, the order does not articulate any rationale upon which the trial court issued its decision. This court has found a difference between a failure to articulate particular details of a rationale upon which the trial court issues its decision and failure to identify any rationale at all. Here in this case, we don't know why the trial court did what they did. We don't know which exception they thought was applicable, if any, or even if they recognized the general rule of bifurcation as articulated by the court administrator or under CPLR 603. For that reason,
Counsel, let me ask you this, just, I want to understand your argument. The trial court is, as we all know, I mean, this is an abuse of discretion standard. They have abundant discretion to make these kind of decisions. But you're saying that even though there was an argument before the court, which articulated the two sides to why or why not bifurcate this case, and so the court was fully briefed on this and fully understood both sides of the argument, that because the court did not articulate the specific reasons the judge was relying on, that somehow that implicates the court's discretion to make a decision?
Two responses to that, Your Honor. First, I would say obviously this court can exercise its discretion and find that one of the exceptions did apply.
Well, let's stay with us looking at, did this judge abuse its discretion in this ruling?
Sure, I would say that the uniform rules of procedure speak to that, specifically Rule 201.1B, which states that any of these rules can be waived upon a showing of good cause and in the interest of justice. Here, the trial court didn't articulate any rationale, like I said, but certainly not good cause, and they didn't do so in the interest of justice. So we would say that in those circumstances, and certainly where the danger of prejudice is present, that would be an abuse of discretion, regardless of the sufficiency of the underlying papers. But again, moving to the sufficiency of the underlying papers itself, specifically, as I mentioned, there are two limited exceptions that this court has recognized. First,
sorry, just to follow up on our presiding justice question, didn't both sides have a chance to be heard in front of the trial court?
Yes, Your Honor.
And the trial court, at least what this case law says, we shouldn't disturb that because, unless there's some abuse of discretion, correct?
That's correct, Your Honor, but in order to disturb it, there would have to be a rationale under which the trial court issues its decision. And based on this record, we don't know what that rationale is.
Or are you saying that there's no rationale that would apply? That's what I'm hearing.
It's both, Your Honor. Under the circumstance of this case, there is no rationale under which bifurcation should be denied. But additionally, the record is not clear as to what rationale.
Judicial economy not be appropriate.
Your Honor, judicial economy is a factor that should be considered by the trial court in determining issues of bifurcation. But the question is whether judicial economy is sufficient by itself to overcome the presumption of bifurcation. This court has recognized in Mazur v. Mazur, there are situations where it is. Specifically, the second limited exception, which is that the liability phase and the damages phase of the trial are both going to be short. Here, plaintiff respondent is alleging that the liability phase of the trial is going to be short. We don't dispute that. We agree that the liabilities phase can be handled in a day, but rather it's the damages phase of this, if it were to be conducted, which would be quite extensive. Not only are there issues of medical causation that need to be determined, there's your medical experts are going to have to testify on all of the various alleged injuries the plaintiff respondent has alleged.
Instead of a 3-day trial on liability, you're talking maybe a 6 or 7 day trial if you add in the medical witnesses.
That's correct, Your Honor.
But I'm going to transpose that. What about the idea that after a decision is made with regard to the liability, you're probably looking at another year before the plaintiff gets to put their proof on, or maybe 6, 9 months, whatever. It's going to not just be a few extra days. It's going to be months, maybe a year down the road. And my understanding of this case has already been a 6-year delay. Accident happened 6 years ago, and it's still not done.
Two responses to that, Your Honor. First, regarding the extensive delay, 2 years of that delay was due to the plaintiff respondent, who was deposed, indicated they needed to get another surgery, but they were putting it off for their own convenience and work-related issues. And then only 2 years later did they get that surgery, after which we were able to move to this motion. To the second point here, I'm sorry, Your Honor, can you repeat the first part?
That we're talking about a trial that went from maybe 3 days on liability to now doubled, okay? By the time we have the witnesses, as opposed to a very long delay by the time we regroup, order all those medical witnesses to be present. We're talking 6, 9 months, maybe a year.
Thank you, Your Honor. I think that requires two speculative assumptions, which.
Well, listen, I was a trial judge for a long time, and I can tell you, I never did one of these medical cases within a short amount of time. It always takes a long time. Certainly more than the extra 3 or 4 days to put the medical witnesses on now.
Let me be clear, Your Honor. I'm not suggesting that it wouldn't be an extensive delay if the damages portion were to be had, and it would take a while. What I'm saying is that it requires two assumptions. One, that the defendant appellants are not going to prevail on liability. And two, that after the liability is properly apportioned by that determination in the short trial, that wouldn't lead to a settlement. Here, as in the case with many insurance matters, once liability is apportioned, settlement is much more likely and a resolution of the case can be reached.
Doesn't your expert say that this is not related to it and it's a low impact accident and everything's pre-existing? So where's your settlement possibility there?
Your Honor, that's specifically to the medical causation issue. That's a different issue from the actual liability or negligence issue. Here, the liability issue is that Mr. Mokel was positioned in the driveway. There was some exchange of waving each other on, at which point Ms. Calvinesso proceeded. He looked back and forth. He didn't see her. And it's unclear whether, it's clear that she went on the right side of the truck rather than properly entering the driveway on the left side of the truck. She states that's because the truck was turned and she couldn't enter the driveway there. He states he was properly positioned. She went past his truck and then tried to enter on the grass to the right of his truck.
Just to add on to Justice Montour's question, I think he was saying the issues are intertwined, so it would be better fit that it'll be in one trial as opposed to bifurcate.
Your Honor, we disagree that the issues are intertwined, but even if they were, plaintiff respondent has waived that argument. They didn't argue in the initial instance of the trial court that the issues were intertwined to subject them to override the general presumption of bifurcation. So even if there was a possibility of making that argument, it was waived here.
Counselor, does the rule still state that it's supposed to be a bifurcated trial in front of the same jury immediately thereafter? That was always in the court rules. I didn't happen to look at it before this, but is that still the rule? So it's changed a little bit. Under CPLR 603, it was a much more stringent rule. The chief administrator clarified under the uniform rules that the judges are encouraged to do so. And one of the things that they put in that statute was whether or not bifurcation, if bifurcation would not assist in the simplification and clarification and lead to a more fair and expeditious resolution, that bifurcation is not warranted. Right, but the rule specifically said that bifurcation shall be in front of the same jury immediately thereafter. And that still says that, right? They never changed that. That's correct, Your Honor. And in fact, but is that what you were prepared to do? Or was that, because I know a lot of times in the lower courts they ignore that part. Your Honor, I would say that's a decision for the trial court to make in regards to their calendar. However, they feel that could best be done. Our concern here is more to the danger of prejudice that could result from the jury's, engendering the jury's sympathy to the plaintiff respondent. And specifically, the rule 202-42A outlines a number of protections on behalf of the party not moving for bifurcation, under which how they can question the jury and other issues there that are not really relevant for this appeal, but are articulated in the rule. Moving on to our final point, again, the danger of prejudice here. There is an extensive list of injuries alleged in this. We have neck injuries, back injuries, bilateral hand and fingers injuries, bilateral shoulders, bilateral
Getting into the bill of particulars, are you?
I might as well be, Your Honor. It's quite extensive. And again, it's hard to see how that would not engender sympathy from the jury, especially if it was all combined in one trial and all these medical issues were heard about extensively and in detail. And also, I would point this court to the second department's case in Patina v. County of Nassau, in which they considered specifically this, and they said the probative value of such evidence, referring to the nature of the party's dispute, whether it should be weighed against the degree to which the gravity of such injuries will likely engender sympathy for the plaintiff and thereby pose a risk of prejudice to the defendant. The Fourth Department hasn't had the opportunity to speak to this issue yet, whether prejudice itself is enough to find that the general rule of bifurcation should apply and court calendar or the efficiency of judicial economy should override that concern. And we would ask in the absence of that precedent to look to the Second Department's rationale. And specifically because the trial court failed to consider that as a factor, and there's certainly no evidence in the record that they did so, that in itself would be an abuse of discretion. Unless your honors had any other questions.
No other questions, counsel. Thank you.
Thank you.
May it please the court, Leah Costanzo for the plaintiff. The defendants argue that based on the record that it's not clear how the trial court came to its conclusion, but they're the ones that failed to include in the record the transcript of the oral argument before the judge where there was extensive discussion between counsel and the judge. So I don't think it's fair for the defense to rely on a record that they submitted that was incomplete, where the court cannot consider what the discretion is that the court engaged in denying the bifurcation in this case. But initially too, the Fourth Department case in Fox that we cite, bifurcation is improper if the nature of the injury bears importantly on the issue of liability, or it wouldn't assist in clarifying or simplifying issues and provide a fair and expeditious resolution of the case. Defendant's brief argues in number one that a low speed impact cannot cause the injuries that plaintiff sustained. So their own brief attempts to argue that they may submit some medical evidence in the bifurcation trial because they want to establish that this low impact accident cannot cause her injuries, which is supported by their own doctor.
So is that intertwined?
Yes, Your Honor. And even so, the other improper reason for a bifurcation is the fact that it wouldn't assist in clarifying the issues and expediting the trial. In this case, defendants are defending not only on liability, but also on injuries. They don't believe any injuries are related. So I think liability is more complicated than defendants want to indicate. I don't see an instance in this particular matter where a jury decides, the possibility or the large possibility that both parties are at fault or that the defendant is at fault, which leaves the defendant in the case for a liability trial where the defense is now going to argue that the plaintiff didn't sustain any injuries from the accident, guaranteeing a second trial. We are 6 years into this litigation and 8 years past the time of the accident. Obviously, plaintiff disagrees with the fact that she was the reason for the delay. There was extensive COVID. She was scheduled for the second surgery. She was the night before there was a second bout of COVID. It was canceled and then it needed to be rescheduled. But regardless, it doesn't matter. There's of the facts that are presented in front of this court, there's no indication that this could be more expeditious in resolving this case from what's been presented. So I think for that reason, the court was in its proper discretion to control its calendar and judicial economy and indicate that it wouldn't be appropriate in this matter.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you, counsel. Case 287 in the matter of Janet Hess. Proceed, counsel.
Morning, Your Honors. I believe it's still morning for a couple more minutes. My name is Amanda Lau. I represent Barrett Hess, and we appreciate the ability to be here today to discuss what we believe was an erroneous decision by the surrogate judge who afforded full faith and credit to the Florida court decision after we raised issues regarding due process under the Florida court decision. As we've laid out in our papers and we advised.
Was there a judgment of divorce in Florida?
There was, yes.
And your client was a party to that judgment of divorce?
He was, yes.
The judgment of divorce, the order emanating from that indicated that that emanated from that judgment of divorce indicated that he appeared and was heard on that proceeding, correct?
The language of the order reflects that. There's an affidavit from my.
The order says he was there.
Yes, the order does say that.
There was no motion to modify the order, change the order, to correct the order.
At that time, no, there was not.
Right. And action was taken by your client pursuant to that divorce happening relative to property distribution, including a transfer of title to the house in Florida?
Your Honor, so there was a deed that was
Did-
filed about
Did
4
a
months
deed
after.
change after the divorce that put the title fully in his name?
The court order, if it is valid as the respondents say it is, it would transfer automatically under that judgment of divorce.
Okay. And so that title transferred after the order was in place.
Correct.
He became the sole owner of the house in Florida.
That would be if we are still arguing that
The order
is void.
The order was signed and filed,
It was.
right? It wasn't vacated, it wasn't changed. By operation of law, he became the title owner to that house in Florida. You're agreeing to that?
I am agreeing that under the respondent's argument that it is valid, that yes, he gets to be the owner of that home. However, in terms of their arguments on the briefs, it's a reliance or collateral estoppel argument, right? That he should be collaterally stopped from attacking that judgment. We submitted in our papers that we don't believe collateral estoppel should apply as a void order is void is void is void. It doesn't become less void because of the moral character of the party that you're attacking.
Your client got a divorce, acted under the terms of that divorce, and you now want the divorce to not be considered a divorce. He wants to go from being a divorced man, the marriage over, to having the divorce not be in effect or have any gravity. And then he gets to become the heir to the now deceased ex-wife's estate. That's the plan here, right?
That is the argument that's been raised by the respondents.
Let me ask you this. When the petition was filed, he was petition for probate, he filed it, right?
Correct.
Okay. In that petition, was there any reference at all to him being, that there being an order of divorce in Florida in effect?
I don't recall that, Your Honor.
You don't recall it?
I do not.
Okay. Continue.
Thank you, Your Honor. As we've raised in our briefs, we believe that the Florida court law applies and that the surrogate should have reviewed under Florida court law and statutes whether the due process rights were.
Why should the court have done that? Nobody raised that issue.
Mr. Hess did raise that issue,
Okay,
Your Honor.
but not anywhere near the time of the alleged divorce. Only after her death. He raises that issue,
He
but
did raise the issue in Florida before her death. I believe that's in his affidavit, that his motion to vacate that judgment was withdrawn without his consent.
He was counseled to withdraw that affidavit because he could get into trouble if he continued pressing that.
Which, as he understood, he didn't understand what that would mean, and he still did not consent to it.
He was an attorney, right?
Yes.
A New York State attorney.
He is a retired one. Yes.
Yeah, but I mean, he practiced law.
He did, yes.
Yeah. Okay. Anything further?
Your Honor, we just respectfully submit that the surrogate should have reviewed under Florida court. We've provided Florida court decisions about what due process means, including receiving notice of hearing, and that we've created an issue of fact about whether that occurred.
We'll take a look.
Isn't he arguing that his wife, he's arguing the wife's standing, lack of standing, because he's arguing that she didn't receive notice, the notice that he sent to Chautauqua with an understanding that she doesn't get her mail anyway, so she probably won't get that, and she probably won't have notice, and I can get a default.
Well, Your Honor, that the point about who can raise the issue of notice under Florida court, there's nothing statutorily or case law saying that it has to be one person or the other when it comes to a void judgment. The judgment is void, it's void, it's void. It doesn't become valid against one party because they received notice and the other party didn't.
yeah, so people default all the time and judgments still get taken.
Understood, Your Honor. And I think that's the distinction here between how New York functions and how Florida does. Because as we put out in our paper, the third prong is whether there's certain due process requirements that are met. And that's why we cite to Lemoyne, we cite to Specter.
Those are
Judicial.
due process rights.
I'm sorry?
Those are the decedent ex-wife's due process rights.
Again, Your Honor, that's what we've raised in our brief in terms of the circular argument. The respondents argue that Barry can't argue the divorce decree is void because he's not the executor, so he's not standing in her shoes. But at the same point, they're arguing that Barry is not the executor because the decree is valid, right? And I would also just submit one additional item. At the time the surrogate raised or made this decision in this case, there was no one standing in Janet's shoes.
And again, when you're saying waiving her rights as far as notice of this, not having notice, she brought this divorce proceeding, right?
She did, and there's no doubt here at the beginning that there was jurisdiction, but in Florida, that's not the end of the end of the analysis. It continues on.
It seems like the court made all the appropriate analysis when they indicated that the husband was there and he testified and there was an equitable distribution. To each party got $2.8 million worth of assets. It appears as though now it looks as though he's trying to lay claim now to her 2.8 million as well.
Your Honor, I understand that there is an argument by the respondents that this is all about money, right? I get that argument.
Maybe.
However, I would point out to the facts that he's put in his declaration that would undermine that, right? So after this.
So he doesn't want the money.
I'm sorry?
He doesn't want the money.
To him, it's not about the money. I mean, a person.
Wife's due process rights being violated.
A person who is all about the money would not have rented her properties, paid for her travel, paid for her cultural events. All of this is in the record, arranged for her dog walkers, maid services, paid for issues in the house, paid for a private charter, paid for her doctor's bill, health insurance. That's not someone that's all about her money. That's someone who was treating someone as their spouse.
Anything further, Counsel?
No, Your Honor.
Thank you.
Good morning, Your Honors. May it please the court. Michael Zoller of Hodgson Russ on behalf of respondent Jennifer Hess. The question in this case is whether a New York court should undo a final Florida divorce judgment at the behest of the very spouse who sought it, who participated in it, who relied on it, and is now repudiating it. A party who receives a notice of a Florida hearing cannot challenge a judgment arising from that hearing based on an alleged notice defect to his adversary. Here, appellant asked this court to make new law so he can attack the Florida divorce decree he obtained on the basis that his ex-wife Janet did not receive proper notice of the hearing. Appellant asked this court to adopt this novel theory without citing a single case on point, i.e. a case where a party who received notice of a hearing and obtained a judgment subsequently attacks the very judgment they obtained on the basis that their adversary did not have proper notice. The court should affirm the decision below that the Florida divorce decree is valid and entitled full faith and credit because it is undisputed that appellant had proper notice of the divorce proceeding. The court actually need go no further and can affirm on that basis alone. There are three other arguments we have: judicial estoppel, equitable estoppel, and the fact that appellant.
So those arguments are in your papers?
They are, yes. And one point actually going to what Your Honor raised before as far as the deed. So first, the actual divorce judgment transfers the marital home to Mr. Hess, the appellant. But actually, it's even worse than that, Your Honor, because subsequent to that order being entered, Mr. Hess executed a deed transferring that same marital home from himself to his revocable trust. He signed that deed in his capacity as a single man. So years after this divorce decree was entered, he affirmed in a document that he filed with the Florida clerk that his divorce was valid, that he was a single man, and that he took the marital home. So the standard here is that a sister state judgment is presumed to be valid and will be given full force and effect unless the opposing party can meet the heavy burden of showing the absence of jurisdiction. Again, appellant can't meet their burden here. Appellant petitioned the court in Florida. Appellant received notice of the hearing. Appellant testified during the hearing. The court relied on the appellant's testimony in valuing the real property that it assigned to him. And then appellant effectuated that the division of marital property. Again, he did so not only by taking the marital house as part of the judgment, he then transferred it to his own revocable trust.
And you represent the children of the marriage.
What's that?
You represent the children of the
I
marriage.
represent the daughter. There are so there are three children in the marriage. I represent Jennifer Hess. There are two brothers. They do join in this in our argument today. I'll go through again every single case cited by appellant: Spector versus Uber, Reisel v. Gregg, Polani v. Payne, Lemoyne Group LLC versus Edgewater South Beach Condominium, Toulouse v. City of Fort Lauderdale, Rodriguez v. LS Commercial Funding LLC, Watson versus Watson, Lee v. Lee. Every single one of those cases involves a party who did not receive notice of a hearing, challenging the judgment based on an alleged notice defect to them. In not one of those cases did the party argue, oh, the judgment is invalid because my adversary didn't receive notice.
No, we're aware of that argument. Counsel, is anything further?
The only other thing I'll say, Your Honor, I'll skip to, I guess, our very, very last point, which is, even if he could raise the argument based on Janet's based on the fact that Janet allegedly didn't receive notice, they actually did not establish here or raise a tribal issue of fact on that point for two reasons. First, here, the judgment itself says that notice was mailed to Janet. One of the cases, they cite Spector v. Uber. In that case, a notice of a hearing was mailed to a party's counsel. That party's counsel then withdrew. That party's counsel did not forward the notice to the litigant. The Florida court nevertheless held that, well, mail service is okay in Florida. It withstands constitutional muster. We mailed service to your counsel. That's good even if you did not receive actual notice. Here, their argument fully relies on actual notice. They say, oh, well, Janet didn't go down to the mailbox to retrieve her mail. Well, even if that were true, and again, they don't even raise a tribal effect that it is true. But even if that were true, it's irrelevant. Proper service was achieved by the mailing. Also, the very last point is their argument on that Janet did not receive notice is based on one, the affirmation of appellant, which is self-serving and says upon information and belief, she didn't go down to get the mail. The fact that it actually says upon information and belief, as a matter of law, that does not raise a tribal issue of fact. There's a case, I believe it's Wood v. Norse, from this department that stands for that proposition. And then lastly, they rely on the affidavit of a caretaker, Douglas Rashbrook. Rashbrook says he didn't get the mail for Miss Hess, and that he was not aware of any other caretakers getting the mail from Miss Hess. Again, that's just pure speculation that nobody else did, or that she never went outside his presence. So for all those reasons, the Surrogate's Court got it right, and the judgment should be affirmed.
Thank you, counsel.
Thank you.
Case 288, Whitfield versus Waterloo Central School District.
He's on the TV.
Very well.
Sorry.
Counsel, can you hear us?
Yes, Your Honor, thank you.
And we can hear you. Counsel, please proceed.
Good morning, or maybe afternoon, Your Honors, and may it please the court. My name is Ken Lowe of Cantor Wolf McCastro and Hall. I'm here appearing on behalf of the claimant appellant. Given the submission of the respondent in this case, I think it's important not to lose sight of what we believe is the simple fact that the law implicated in this case is very much in favor of claimant's position. We believe that the court below ignored relevant case law and abused its discretion in conclusorily denying claimant's motion. I think it's very telling that respondent's entire preliminary statement is dedicated to a public policy argument. The law is not on their side. It's an exercise in distraction and misdirection, not to mention the public policy argument is misguided. There's no question that the infant in this case is troubled, but the public policy focus here, if any, should be on the systemic bullying that, despite respondents' knowledge thereof, went unchecked and unaddressed by respondents, despite the reports. Respondents' position attempts to absolve them of responsibility and complicity in the persistent bullying that pushed a client to extreme and unfortunate ideation.
Counsel, let me bother you for a second.
Sure,
Okay,
please.
the infant plaintiff is still under the age of majority, so their statute of limitation is not expired.
That's correct, Your Honor.
And then your other argument is that the school district had chapter and verse about knowledge of what went on here, okay? And you showed that by some of the our prior lawsuit, okay, that we handled here, the prior appeal. And you showed that through, there were DASA complaints, and the mother's testimony that she called both the village and the school district office, okay? So I think you covered in your application both ends of the requirements here, that there's still time left on the statute of limitation and that the school district, you know, had all of the pertinent facts here. Okay.
Oh, I mean, thank you, Your Honor. I think I'm inclined to agree with you.
All right. All right. If there's anything else.
If Your Honor is indicating that you would not like me to.
Don't assume any indication.
I was just summing up because I thought you were missing the one thing that you spent a lot of time in your brief with.
Sure.
Which is what they knew about the incidences that gave rise to you wishing to put in a late notice of claim.
No, thank you, Your Honor. I appreciate you bringing that up. No, I was about to get to the more pertinent points, I think. But like I said, respondents dedicated so much of their papers and the first maybe 5 pages of it to these public policy arguments that I thought, you know, rather than regurgitating the points that I'd laid out in my papers, I would address those. But I mean, that being said, I do think general municipal law is very much in favor of us. I think that the case law indicates that the courts are to construe the criteria liberally, and I don't think that the court below did that at all. As stated, I think it's very conclusory and fails to address any of the law that we cited. And I think it's important among all the things. Again, Your Honor mentioned, you know, the actual notice element. I think that's clearly laid out in the papers. The reasonable excuse, I think, speaks for itself that she was dealing with these criminal proceedings and her child being taken out of her custody for a significant period of time. And as for the prejudice, you know, there are essentially 3 important steps here that happened. You know, there was the bullying itself, which was reported. There was an investigation in the criminal matters. And then after that, there was also the July 2024 notice of claim that we served without leave in order to try to further stem any potential prejudice. And so I think that more than meets the standard that's been laid out in the common law, in as much as sorry, I lost my train of thought, but the burden shifts is the bottom line, is that once we have put up a plausible argument that there is no prejudice, the burden shifts to the other side. And the respondents responded with absolutely nothing, not a single document to support their position that they were prejudiced, just pure speculation. And unless there are any further questions, I will rest on that.
No further questions, counsel. Thank you.
Thank you.
Counsel, proceed.
Good morning, Your Honor's James Special for Waterloo. A couple points that I want to mention is first on the prejudice point. I don't believe that plaintiff ever met their burden on that one, because and the trial court actually pointed this out, that for this case to proceed, we're going to have to rely on memories of very young children. They don't really put anything forth that clearly points out that the relevant people, even claimant, her son, remember this clearly. And this kind of reminds me of the point of the case we just heard that we were just listening to, where they just say, oh yeah, we think that everyone will remember all of these facts. And I don't believe that the trial court's decision is conclusory at all. For instance, one thing that the trial court says is that he says it wasn't lost on him that they tried to file a notice of claim in 2024. Then there's a gap until April 29th of 25 when they finally make the motion. And given that we're looking at an abuse of discretion standard here, I mean, is there enough to say that the judge abused his discretion? And if you look at it, I don't think it's conclusory at all. I think it's laid out very logically in fact, and the judge backs it up and explains his reasoning. So I definitely wouldn't say it's conclusory at all. And for that reason, given that it is an abuse of discretion standard, I don't think there's enough to say it was an abuse of discretion.
Thank you, counsel. Any further?
Nope. Unless there are questions from anybody.
No questions.
All right. Thank you.
Thank you.
Thank you.
Case 289, Village of Allegheny versus City of Olean. Okay, very good. I believe we have both counsel on the screen. Can you hear us, counsel?
I can, Your Honor.
Okay, very good. And Mr. Spitzer, would you undo your mic so we know we can hear you?
Yes, Your Honor, I can hear you and hopefully you can hear me.
We can, just for when the time comes. Very good. Counsel, proceed.
Good afternoon, Your Honors. If it may please the court, Charles Grieco, Bonchenik, and King for the Village of Allegheny. Our position here, we believe, is fairly straightforward. As I believe Your Honors are aware, this is a case that is a dispute over some intermunicipal sewer arrangement and some charges between the city and the village. And in this case, by way of counterclaim, the City of Olean asserted a number of counterclaims long after it had served a notice of claim in 2022 that was very clearly, quite explicitly, based on a breach of contract theory. It was seeking damages of about $1.1 million for certain defined costs that it alleged the village owed because of a intermunicipal agreement between the city and the village. It also sought declaratory relief for the court to declare the parties' rights and obligations under that agreement. The notice of claim could not be more clear on that point, and that is the only relief, the only claims that were included in that notice of claim were a breach of contract claim and declaratory judgment claim for declaration of the parties' rights under that agreement. However, when the city served its answer to the village's Article 78 and declaratory judgment action, seeking to require the city to negotiate an agreement and to abide by the terms of the agreement, the city asserted counterclaims that not only were not based on that contract, but explicitly sought to repudiate that contract. Their first cause of action was to declare that the contract did not exist. It had expired. It then sought to...
Counselor, by promoting those or advocating for those counterclaims, contrary to the notice of claim, which apparently just alleged a breach of contract, your claim is that this is a violation of CPLR 9802?
That's correct, Your Honor. And we think that that is clear from the language of 9802 and a uniform body of case law interpreting 9802. 9802, unlike some other notice of claim requirements that are found throughout New York statutes, is very clear that a notice of claim is required not only for contract actions, but any other action. No other action shall be commenced against a village without a notice of claim. And the courts have interpreted that to that no other language permits of no exception. So therefore, courts have applied that, or have held that notices of claim are required in the context of seeking equitable relief, declaratory relief, extra contractual relief, or non-contractual relief like quantum merit, as the city's, one of the city's counterclaims is in this case. There is no scenario, there's no claim essentially that you can assert against a village that does not require a notice.
What about the fact, as far as the notice is situation, as far as the purpose of the notice of claim? I believe that the city's going to argue that they sent all these letters to you. There was invoices that were sent to you, so you absolutely had notice of these contentions that we're making that you should then be responsible for these particular payments.
Well, so again, we think the case law is perfectly clear, and it comes from the Court of Appeals that has made this point, as well as several appellate divisions, that the notice of claim requirements are strictly construed, and that they apply regardless of whether the village or the municipality has actual notice of the claim. The case law is also clear that you cannot, mere correspondence between parties cannot substitute for that strict compliance requirement for a notice of claim. And with regard to that correspondence, I would also point out that the village was very clear that it never agreed with the city's assertion that it now claimed it could unilaterally charge rates that were not set forth in an agreement between the parties. So and we don't believe the city cites any case law whatsoever to support the notion that merely because the mayor at one point sent a letter, said, you know what, we're no longer operating under this agreement. We are now going to charge you in a different way that we've determined. And then and when the village responded to that, saying we completely disagree with that, the village, frankly, the city was obligated at that point, if that was its new theory and its new claims, it was obligated to file a notice of claim, and it didn't do that. It simply asserted counterclaims without the benefit of a notice claim that are based on completely different theories and, frankly, different costs.
There were no efforts to amend that notice of claim?
Well, as the city pointed out in the reply brief, I believe, or maybe it was in their initial brief, they have subsequently filed a notice of claim, but that's not before the record on this court.
Right.
And we can argue when we go back below as to what the effect of that notice of claim was, but no, there was no attempt to amend their notice of claim. But importantly, on that issue, if you look at their notice of claim that they did file in 2022, they did seek to reserve the right to amend it, but it was specifically to say that the city reserves its right to amend its statement of damages as necessary to properly reflect the monetary loss it has recurred as a result of the village's breach of contract.
Still the reference
that it was going to.
Still that reference to the breach of the contract. So
absolutely, everything in their notice of claim is completely premised on a contract that they now seek to repudiate.
Anything else, Council?
I would just quickly address the exceptions that the city seeks to rely on. And that is, well, first of all, at one point they allege that 9802 only applies to contract actions. That's just clearly wrong as a matter of law. But then they seek to do that it shouldn't apply here for basically two reasons. One is that the village should be estopped. And they cite a number of cases where estoppel has been applied in the notice of claim context. But the case law is uniform in saying that estoppel is a narrow exception that is only applied where the party who failed to file the notice of claim was induced to not file that notice of claim and justifiably relied on either the negligent or intentional miscommunication, misdirection, misconduct on part of the party. This record is completely devoid of anything that could suggest that the village induced the city not to file a notice of claim once the city decided it was pursuing a different theory of recovery. And we think that the case law is very clear on that. The other exception that they seek to rely on is the public interest exception. And again, we think that simply does not apply in this scenario. The cases that, we cite in our brief to cases that involve disputes just like this between municipalities where the courts found that the public interest exception did not apply. That's the Muttontown case and the Macedon case. They cite to a number of cases that have held that a notice of claim is not required under very unique circumstances. And that is where somebody is claiming to vindicate an important right, not for itself, but for all similarly situated class of the public. And the resolution will directly affect the rights of that group. And if you look at the cases that they rely on, the Cayuga case, the Rampello case, the Yagan case, those are all very, very different situations here where the courts found there were specific issues there that applied, that where requiring a notice of claim was going to frustrate a different part of the statutory scheme, or were frankly just facial constitutional challenges that weren't based on facts. This is a fact-specific dispute here between these parties. So we don't think the public interest exception has any applicability here. And I apologize if I already mentioned this, but just on the last argument that I want to address, if I didn't, was the notion that somehow communications between the parties can satisfy a notice of claim requirement. As we point out, the courts have recognized in Filson and the 110 case and the Appellate case that is not a substitute for a notice of claim requirement simply because the parties shared some correspondence. And in this case in particular, what the correspondence shows is the city was arguing to the village what its position was, and the village consistently said, we disagree with that. The cases where sometimes the courts have been a little more liberal on the notice of claim requirement is that there's an acknowledgement on the part of the village or the party who was required to have a notice of claim served upon it, which again is really similar to the estoppel situation where the actions of that party have given the party that's required to serve the notice of claim some reason, justifiable reliance not to do so. Those facts simply are not present in this case. And with that,
I think we have your argument, counsel. Thank you. Counsel, proceed.
Thank you, Your Honor. Daniel Spitzer on behalf of the city. May I respectfully suggest that, and particularly going to the issue of the amendment, the city was put the village on proper notice from the beginning of this very long dispute that goes well back before 2020. And the notice of claim, while it covers part of what's in front of you and why the judge properly refused to dismiss these counterclaims, it also is important to note that the city, in fact, did amend with the August and December letters, which are in the record, and the village responded to the August letter, contrary to that. That's in the record. So first, let's talk about the first counterclaim. They said, oh, you can't raise a declaratory judgment about contract rights under a notice of claim about contract rights. Let me respectfully note to the court that there's an affirmative defense in front of the lower court, that the contract expires. They have not moved to get rid of that affirmative defense. In other words, the court still has to decide, is this contract in place? If the contract's in place, then all of the counterclaims are properly in the notice of claim, with the exception of number 6. I'll get to that separately with regard to the environmental conservation law. If, in fact, they are correct, then the money they owe us under the August letter, under the December, all the bills, is calculated under the contract. And the notice of claim goes specifically to their failure to pay those amounts. They keep forgetting that they haven't paid the amounts under that contract. Part of this case arose because the city residents have been subsidizing the village residents because of they simply chose a number, 300 grand out of the air, that they were going to pay. They weren't going to rely on the city budget. They argued about what's in the city budget. They breached the contract. In addition, the contract terminated by law. There is an affirmative defense that first declaratory judgment action is still going to be before the court. It's certainly, I would respectfully argue, what a claim that discusses the rights of a party under a contract certainly includes whether that contract has expired. As to the other two letters that very clearly laid out, let us first note that paragraph 24 of the contract that they want to keep in place says that the village will continue to follow the code. In other words, the city code governs this. Their causes of action related to the fees are under the city code. Yet they want to say that a separate cause of action wasn't included in that August letter. The August letter says this is a formal notice. It qualifies completely on its own under 50E, excuse me, as a notice of claim. It was sent to the right party. It was served on their council. It includes bills that explain how the city came to the amounts due. It explains what the law was that was applied. And you have nothing in front of you, and Judge Parker had nothing in front of him that says that that notice of claim of August was not sufficient under 9802. As we point out, as you pointed out in the, I'm probably pronouncing this wrong, the Bettet versus County of Monroe case, you can have amendments of notices of claims as long as they arise from the same facts. So you can't bring a counterclaim that says, by the way, the village truck ran into a city car, you owe us money for that. But you can have, when you have breaches that lead to ongoing debt requirements and ongoing payments, you most certainly can have updated bills. You most certainly can have additional comments. And if you look at that August letter, you look at that December letter, which they are stopped from denying they had for the very reasons my good colleague, Mr. Greco, said, because they responded to the August letter and acknowledged it. They disagreed, of course, and there's certainly factual disputes to be determined below and legal disputes.
So it's your contention that the village had notice of all these factors?
A notice in spades.
And they're related to your notice of claim. Is that right?
They're related to our notice of claim, and obviously, in terms of events that we're applying to after the notice of claim, in terms of the debt, we reserve the right to update the debt, update it. They were still paying under the contract. We were saying the contract didn't apply. I think that goes right to the very term of the notice of claim. What are your rights under this contract? They claim we still have a right only to be charged under this contract. And now they're saying to you, oh, but it's not a notice of claim related to whether or not we have to be charged under this contract. I think they're trying to have it both ways. And we really ought to get this back on all 6 of these back to the court below to determine the factual issues. If the contract expired, what was due, what was fair, did the contract expire, we think is obvious, but it's not before this court. I would also note on the 6th cause of action, there's no requirement for a notice of claims on environmental conservation law. That's a separate item. It has nothing to do with contract or equity. You're not allowed to violate state law. We are the enforcement agency. We have a right to bring a claim, and they have violated multiple times. We brought it in this court rather than filing a complaint with the DEC. We thought that was appropriate. But there is no question, and they certainly don't deny, Your Honors, that they had full notice of everything. They're simply trying to say a hyper technicality. Yes, we had notice. Yes, we knew you from the affirmative defenses and from your letters that called themselves formal notices that you believe they expired. Yes, we had noticed that you applied this code. You had every single thing under 50E in writing, but somehow we didn't have notice of claim. Judge Parker should be affirmed. We would respectfully ask that the 2nd and 6th causes of action, counterclaims be restored. Other than that, I will stop ranting and happily answer any questions.
Thank you, counsel. Case 290, Bush versus County of Erie et al.
Good afternoon, Your Honors.
Counsel, proceed.
Jeremy Toth, I'm filling in for Eric Marriott, and I will be very brief. It's essentially our contention that when a federal judge, after several years of litigation, makes a ruling on a summary judgment motion, it is not an opportunity to kind of get a do-over or start over. You still have to plead a cause of action. You still have to abide by statute of limitations. You still have to have a notice of claim if that's appropriate. And so for those reasons, we're asking this court to overturn the lower court's denial of our motion to dismiss.
Thank you,
All right,
counsel.
great.
Unlike you, Mr. Coates, unlike.
Counsel, proceed.
Hi, Your Honor, Blake Secondino on behalf of the plaintiff here. Judge, I'll be brief as well because I know it was a long brief. Our basic argument is that the Judge Reese in federal court dismissed the claims, the state law claims without prejudice with the right for us to refile. We feel that we had made all of the claims that we put into our new complaints in state court that we refiled in our federal court complaint, specifically on the failure to maintain the premises. We expressly put that in our amended complaint, which is what Judge Reese ruled on. We feel that we've cited many cases that discuss the obligation of the jail to maintain a safe sanitary environment, to provide proper food to these inmates.
But isn't the question whether it's litigated in federal court, not whether he gave the right to refile, it's whether the actual facts were litigated?
Yes, Your Honor. And my response on that would be that Judge Reese did not rule on any of our state law claims. She ruled on our civil rights 1983 claims. And I think we cited some case law in our papers where the judge specifically held that a person could be, or a county government entity could be negligent, but still not found to be liable under a 1983 claim. So that's our basic argument, is that the judge declined to exercise supplemental jurisdiction over our state law claims and didn't hear him.
And since we're being brief, you don't dispute that you're not entitled to punitive damages or attorney's fees, right?
Yes, I would just say on that issue, I was speaking to the claim of punitive damages against the individual defendants. And I know that we did cite to one case in the record that talked about how punitive damages against government entities is not per se unavailable. So we just wanted to make that argument as well.
Very good. Thank you.
Thank you so much. We appreciate it. Okay.
Case 291, Bashada versus Ahmed, MD.
Name's up.
Proceed, counsel.
May
We have everybody here, right? Yep. Okay, very good.
it please the court. My name is Lauren Heimer. I'm here on behalf of Dr. Hamed and Suburban Rheumatology, which is her practice. The motion before the lower court was a summary judgment motion, both from plaintiff side and from the defendant side, and Judge Panapinto denied all motions. So the first question before this court is whether there was an abuse of discretion. We believe that there was not with respect to plaintiff's motion for summary judgment. We believe that they did not meet their burden on causation in particular. And then in response, Dr. Hamed did her own affidavit along with the affidavit of Dr. Karmoudi, who is a orthopedic surgeon. So we covered both deviation and causation, whereby plaintiff did not. And we know that plaintiff acknowledged almost these deficiencies in their moving papers by submitting a second affidavit from the same doctor, Dr. Chatpar, that he did on the first motion as in opposition to our motion, and then put in the affidavit of a retired surgeon named Dr. Hickson, who both of those affidavits can only be considered in opposition to our motion, not as initial moving papers. And then the second component there is that Dr. Hickson was not qualified to render any opinion on this oncologic surgical case. So if we take one step back on the facts, it's that Dr. Hamed was treating this woman for a well-known medical condition called seronegative rheumatoid arthritis. She treated that patient in two separate chunks. The first chunk would be the December 2014 up until April 2016. The patient then left her care And then she returned in 2018, where the subject MRI was read by the co-defendant, not by my client. So it's really important to look at this from Dr. Hamed's perspective to say it had to be deviation from the standard of care within her scope of practice, and that her deviation caused injury to this patient. And so we've proven in our papers, and why we think we're entitled to summary judgment where plaintiff is not, that Dr. Hamed.
Didn't Chadpar opine that Ahmed misdiagnosed the seronegative arthritis?
So the argument was that seronegative rheumatoid arthritis was a clinical condition that was diagnosed. And he said that Dr. Hamed failed to make that diagnosis because he, Dr. Chapar, did not actually look at all the medical records. He ignored all of the bilateral symptoms, the systemic symptoms, the ultrasound, and an X-ray that all happened before April of 2016 to support the diagnosis. So he can say all he wants that if you ignore certain facts, sure. If I ignore the fact that the totality of the circumstances are supportive of rheumatoid arthritis, then the diagnosis was wrong. And even Dr. Hamed said at her deposition that she still believes this patient has rheumatoid arthritis, the seronegative rheumatoid arthritis. It's just that when she ordered the MRI that was done in July 2018, Dr. Hamed, gets assurances that there's no cancer. So she continues to treat the patient for the symptoms and the clinical signs that are consistent with the underlying diagnosis of seronegative. And I think the more important issue here is that it's whether or not the treatment would have been different had that diagnosis of cancer been made in July of 2018. That's where Dr. Carmody comes in, and she explains why an amputation was always going to be necessary for this patient as of July 2018. So Dr. Hamed says, yeah, there was no indication for an MRI before 2018, and here's all the reasons why. And when there was an indication for an MRI, here's what I did. I ordered it. I got assurances that it's not cancer. The language of the report says this is not cancer. So she says, great, I'm going to continue to treat you the way that I've been treating you. And then it wasn't until 2021 where symptoms changed again that triggered the need for the repeat MRI. And I think that's all clear in our papers. And that's why Dr. Hamed is entitled to summary judgment on these particular issues. Plaintiff didn't meet their burden on causation. We then met our burden. In response, we get Dr. Hickson, who's attempting to talk about causation, but he's not qualified to do so. And unless your honors have any other questions, I will rest on my paper.
No other questions. Thank you, counsel.
Thank you.
Counsel?
Thank you. Good afternoon, your honors.
Many of our arguments are pretty similar, so I think I'm going to be very brief. I represent Dr. Snitzer. He's a radiologist, and a lot of our papers highlighted the distinction of the fact that his duties to the plaintiff were extremely limited. That was completely ignored by the plaintiff in their papers, both in support of summary judgment as well as in opposition. So
the extent of his duties.
His duties were to review the MRI, make interpretations, and document his findings. And that is what he did. That was what his duty was. Any talk about biopsies, recommending biopsies or care that was subsequent to his MRI, that is beyond his duty.
Whose duty then was it? I mean, once his report is filed and it's sent to Dr. Ahmed, right? Once that happens, if there is a need for a biopsy, whose responsibility is it to indicate that?
That is the treating physician who's managing the care. So in this case, it's Dr. Ahmed.
So but he had no direct communication with the patient, correct? So it would have had to have been in his report if you were to make that recommendation.
Oh, yes, absolutely. This goes to his limited role. He sees nothing but an MRI and the requisition for that study. He doesn't have any medical records. He doesn't know the history of this patient. He has no conversations with the patient where she's describing her symptoms and how long she has suffered.
So his role is very limited, his duty is very limited, he does his job, he takes a look at the films and he interprets them, does a report, sends it off. At that point, he's on to his next film.
That's correct.
Okay.
That is consistent with the law. That's consistent with what he did here. The other issue with regard to so we said that basically that there's no duty. Dr. Snitzer was entitled to summary judgment. We also in our papers, we addressed the issue of proximate cause. And that's what co-defendants counsel highlighted was Dr. Carmody's affidavit. It was detailed, it was factual. She's an orthopedic surgical oncologist. She deals with these type of cancers that Mrs. Rashada had. And she indicates that as of the date of Dr. Snitzer's involvement in Mrs. Rashada's care, that she was going to need an amputation. The location of where the mass was, its proximity to nerves, bones, ligaments, this all would have affected hand.
The amputation was going to happen whether there was cancer or not?
If it had been cancer, it had a biopsy been done, we're saying, even if you got to the point where you said negligence, we're going to address that issue. There's that second prong of proximate cause. And basically, okay, how did this negligence affect her future care? And what in our position, and based on Dr. Carmody's detailed affidavit, is that she was going to need amputation one way or another. That was just the proximity of this tumor being in the hand.
And that's in your argument is at the time that Dr. Snitzer did his reading, did his report and sent it off, according to the expert, at that point in time, whether there was a biopsy or not, if there was a biopsy, it was going to reveal cancer, and that was the condition of the hand, and there was going to be no way to avoid the amputation.
Yeah, that's correct. That's my argument, but it's based upon the expert's conclusion. So that essentially is why we believe Dr. Snitzer is entitled to summary judgment, and that all due respect to the trial court, that they were incorrect in finding an issue of fact.
So it doesn't matter if he misdiagnosed that 2018.
We don't concede that fact.
No, but my question, it doesn't matter.
It would not have mattered. The amputation was the only treatment that was viable. One, to get at the tumor, but also to ensure that it had not spread. And in the affidavit, we talk about that. Fortunately, this is a case where it did not spread. But that was certainly a concern that the doctors who were addressing the tumor would have had. So once the biopsy was done, had the cancer been diagnosed in 2018, there's two concerns. One, hand function. Can we get that tumor out and save some function at hand? But also, can we, for lack of a better word, keep the genie in the bottle here and make sure that this hasn't metastasized or spread outside the hand? Fortunately, that wasn't the case here, but that would have been the thought process that those who would be treating the cancer would have.
So, and again, I think there was some discussions by Dr. Snitzer and maybe in his deposition concerning confirmation bias. He thought maybe, well, he's getting this question or an interpretation in his mind already that it's just the seronegative arthritis.
Yeah, there was.
So he's like, oh, that's what I see. It doesn't appear to be cancer. But you're saying, regardless of that, it was going to be an amputation in 18 or later on in 21.
Correct. And really, I think there's been some misrepresentations about that line of questioning. It was presented in a way from the plaintiff of Monday Morning Quarterback. And if you really look at how he answered that, he was asked if it was confirmation bias, and he agreed, just with the benefit of now knowing,
Right.
he had issued a report. And with Monday Morning Quarterback and benefit of hindsight and a retrospective analysis of knowing that there was a biopsy done and that was a cancerous mass, he was just more or less explaining how it could have happened. So that's essentially our arguments with regard to why we believe Dr. Snitzer's entitled to summary judgment. I can address why the plaintiff didn't meet their burden. I talked about the duty aspect that wasn't addressed at all by the plaintiff in their moving papers. They addressed negligence. They didn't talk about proximate cause, and they only did that in opposition, the court has heard, in opposition to our summary judgment. And they tried to say that, oh, this is my affidavit from Dr. Hickson, and I'm going to address proximate cause in opposition to defendant's motion, but also in further support of the plaintiff's motion. We cited the law that you can't do that. It's statutory and there's case law. It's too late to try and cure a deficiency in your moving papers with an expert affidavit in reply. We also take the position, similar to our co-defendant, that Dr. Hickson doesn't have the qualifications even to render that opinion. And we take the position the court correctly, if it was the reason why they denied the plaintiff's summary judgment, was because Dr. Hickson does not have the qualifications to render opinion as to proximate cause. They attached his CV as part of his affidavit, and you can see that this is a doctor who was retired in 2015. So for him to comment on care that happened years afterwards would not be appropriate. It also was he's a.
Let me just understand that argument. You're saying that if somebody retires from practice as a doctor, that the minute they retire, they're no longer qualified as an expert? Or are you saying the 15 years gap by operation of law, we should deem them as unqualified to act as an expert?
I think it's a consideration in of itself. Would that be enough?
It goes to weight?
Well, no. The weight of the evaluation of the expert's qualifications is where I'm going to, and it is not weight. In of itself, I believe that is a reason why the court could elect to disregard the qualifications. But here it goes even further. This doctor is not treating this type of cancer. They were very careful, I think, in their affidavit to try and suggest that he deals with hand cancers. That's pretty broad. And they cut it very thick in saying that, and I think it was deliberate, because when you look at the CV of the doctor, you see he's a plastic surgeon. And I don't mean that to discredit, that's an important job, but if you're going to submit an affidavit in this case, that's a key distinction. This is a cancer case, and you got a plastic surgeon who's retired, who doesn't set forth in his affidavit any training with regard to cancer patients that didn't occur in 1984 when he did a brief fellowship at Roswell Park, and he's treating cancers of the head and the upper extremities. It doesn't say he's treating the hand. And so, although to answer your question in a long way, is that it's not just that he's retired. It's really more, our point more goes to his lack of qualifications to render a meaningful opinion in this case, in opposition to Dr. Snitzer's motion for summary judgment. But to kind of circle back, you really don't get to the approximate cause argument because of the duty argument that we also raised.
Thank you, counsel.
Thank you.
No, we're not done. We're gonna give Mr. Hayes a chance.
Good morning, afternoon. Any lines of questioning you'd like to throw at me before we get?
Proceed with your argument, counsel.
Okay. On the duty and the proximate cause, because that's where we just spent some time. The duty, among other things, is to read the X-ray or the MRI report correctly. Okay, all the cases they cited were, if the report is read correctly, then you don't have to recommend a biopsy, and people don't necessarily have to, they can rely on your report. Here, he read the report, he read the MRI incorrectly. So he violated that duty in the first instance to read it correctly. Question of fact as to whether he has a duty to order a biopsy or recommend a biopsy. We've got our expert Hickson says, yes, he does. Well, I think our radiologist says he has the duty. Their expert says, no, it's the primaries.
Counsel, let me ask a question about
Yeah.
that. Is the duty to recommend to the treating, who he's sending the report to, recommend that a biopsy be done? Or is his duty to actually order the biopsy? And is there any importance in that distinction?
My understanding is that the cases hold that there is a duty to communicate the need for or the recommendation for a biopsy. I don't know that he has the authority to order a biopsy. So that's your duty, but he read the thing wrong in the first instance, so he's negligent as I see it.
So you're saying that on the MRI of the hand, there was evidence of cancer there?
There was evidence, yeah, that was the very large pannus formation in the hand that was almost the size of your palm. That was there. Everyone agrees, I'm sorry.
What if that's the wrong test? Like, we're talking about, should he ask for another test, but with a mass there, is the right test a biopsy?
That's the only one that anyone has suggested would be the definitive test to determine if that mass was cancerous or a pannus formation or something else. Nobody said that you can do anything else. So that's what everybody says. That was the need in the next step. So,
So in the first instance, he misdiagnosed, is your
Right.
argument.
So that's
And
negligence.
had he diagnosed properly, he would have sent a report out that indicated that biopsy was necessary. Not that he was ordering one, but that he was saying in the report, a biopsy is necessary. That goes to the treating. The treating, of course, can receive that report and make his or her own judgment.
That is correct.
Can look at the report and say, well, I disagree, and I'm not going to order a biopsy in this case, or I will. Right?
And that would get him off the hook, which is exactly what happened on the second MRI. The radiologist, same Winsong group, looked at it and says, this looks like cancer to me. A biopsy is recommended. And the doctor takes it, and that's when we make that further step.
What about the argument that we've all heard just now, that it didn't make a difference, proximate cause?
Right.
Regretfully for this, your client, the die had been cast.
By
It had been
2018,
cast
yes.
By 2018, when the first, that's, so I want you to answer that if you would. That report goes in, whether there's negligence or not, the fact of the matter is the same result occurs.
Two responses. One, our expert Hickson says, question of fact, I think that if it had been diagnosed in 2018 as opposed to 21, that remedial measures could have been attempted and we might have been able to sustain some hand usage, etc.
Amputation was not a fait accompli.
No, he said 30% chance, I believe it was, which is substantial, 30% chance of recovery. So that's your fait accompli thing. That I think there's a question of fact there, all right, regarding that aspect of damages.
What about qualifications of your expert?
Well,
you heard the challenge to the qualification.
Right. He's got cancer experience. I think it goes to weight, but he's got cancer experience. He's still board certified. He's still licensed by the state of New York. That means he's taken his CMEs. He's up to date. To just say to someone that simply because you're old, and I can attest to that, that your credibility and veracity are suddenly out the window. I think it goes to weight. But even if you throw them out entirely, even if the trial judge were to do that, they're all overlooking the fact that if you had done what they said you should do, then she wouldn't have had the hand, she wouldn't have had 3 years of swelling of the hand, loss of use of the hand, pain in the hand. She had growth of the tumor in the hand causing problems. Those are damages, regardless of when ultimately you lose the hand. So those are damages. And then and this is replete in all the medical records in Ahmed's records, that she had these complaints from 2014 on. So she had pain in the hand, swelling, loss of use, et cetera, damages, proximate cause due to this not being diagnosed sooner. So I think that it's that he was negligent for not reading the MRI correctly, and I think that there are proximate cause. As to Ahmed, and this was sort of raised by you all, everybody agrees, looking at the records, looking at the x-rays, looking at everything, that the plaintiff had cancer when she went to Ahmed back in 2014. She had cancer of the hand. That was the cause of the complaints in the hand. And if what had happened as happened to the orthopedic surgeon, she went to an orthopedic surgeon first, and he said, you don't have carpal tunnel, so I don't know what you got, but need to see someone else. So he recommended EMG. She goes to an EMT specialist or EMG specialist. He does an EMG. He said, no, there's nothing wrong with your the electrical movements. You need to someone else. Maybe you should try a rheumatologist. So she goes to Ahmed, who says, I think you have this disease that we cannot prove. We have no evidence of it. For 7 years, we have no evidence of it. I'm making a clinical description and diagnosis, and I'm going to treat you for 7 years, when in point of fact, we know, everybody knows, there's no dispute. Their experts agree, our expert agrees. The problems in her left hand were caused by the cancer starting in 2014 and before. That's what her problem was. This woman treated her for the wrong disease. And I just point you to it. I'm not going to belabor it because I know you'd never do it. But the charge
Could be the first time.
that a doctor has to have the requisite knowledge and skill to practice their profession and what they're doing. And that goes to Pike, and that goes to the Carpenter case, which I think is good law, but it's going to be one of those stealth cases. Nobody will ever mention it, and no lawyer's going to dig it up for another 20 years. But that holds that if a physician practices outside their specialty and tries to treat something that they don't know anything about, and their client admits, I know nothing about cancer, I know nothing about x-rays and radiology, but I'm going to treat this woman for her left hand. And she misses the diagnosis, she gives the wrong treatment, and in point of fact, we don't even know that she has this seronegative arthritis. I think that that Carpenter applies, it should be absolute liability. I'll take negligence. I think that's fine. But and there was just one other very brief thing. I just give me 1 second, if I may. Sir. Oh. We all talk about, all of us, our profession is resting upon the concept that there must be, in these negligence cases, solid evidence, objective proof in support of our claims. You hold it the plaintiffs all the time. And the entire defense is based on a disease that has no objective proof. There's absolutely zero objective proof, evidence of a scientific basis in the record that suggests that she has seronegative arthritis. It is by definition a disease that you cannot touch, feel, or see. It's intuitive. It's clinical. Well, if I was to bring a plaintiff up here and said, well, I have a clinical problem, you guys could laugh me out of court. Okay? For a defendant and a physician to get away with that and say, well, they may have this mythical disease. And that's my excuse for 7 years for not diagnosing cancer of the hand. I think the standards are stronger than that, and I ask you to enforce it. Thank you.
Thank you, Counsel.
I know, so you see, she did that, and what's that?